going to trial is not securing early enough your litigation experts in a timely manner in accordance with the rules of civil procedure. And the litigation experts are the ones who are going to provide the additional evidence that's going to bolster your case at trial. And when you can't get your litigation experts in, I notice a lot of London lawyers try to elicit inadmissible opinion evidence from a non-party expert. And I'll go into a little more detail about what I mean by that. So if you have a litigation expert, you have to comply with Rule 5303 of the Rules of Civil Procedure. So you have to get an expert report, and that expert report provides a roadmap in terms of what that litigation expert is actually going to talk about at trial and provide opinion evidence. You have to get that expert report and serve it on opposing counsel 90 days prior to pre-trial to avoid trial by ambush and to give them an idea of what specific expert you're going to bring. And you have to do that in a timely manner, else you can't have that litigation expert here at trial and support your client. So when a young lawyer, not so young lawyer, sometimes an old lawyer as well, fails to do that and to comply with the rules, what they try to do is to get an expert and a non-party expert. A non-party expert doesn't have to comply with Rule 5303, and that's typically someone like a family doctor. So a family doctor who could just speak about the reports based on their clinical evaluation of the patient or the plaintiff rather, while seeing them during the course of treating them, right? But the issue with that is they're limited in the four corners of the payment rule, where they can only talk about their observations during those clinical evaluations, completing reports for the purpose of treatment. They are not allowed to provide opinion evidence. And some lawyers who fail to properly prepare try to elicit the opinion evidence from that non-party expert. And when you do that, that can create a lot of problems. When you try to do that, first of all, opposing counsel is going to stand up out of their seat and object, right? And the judge in that case will have some remedies as well, right? They could discharge the jury. If it's bad enough, they could actually lead to a mistrial, right? It depends, right? So when you're looking at that, you got to understand the test of admissibility with regards to expert reports, and that was laid out in a 2015 Supreme Court of Canada case called White, Burgess, and Halliburton Company. And you first have to ascertain whether or not that particular expert who's providing evidence has met the threshold requirement for admissibility, so relevance, necessity, whether or not there's an absence of any exclusionary rules, or whether or not it can provide that opinion was provided by a qualified expert. If you meet those preliminary threshold requirements, then a trial judge has to ascertain whether or not do an analysis of whether or not the probative value of the actual evidence outweighs the prejudicial effect. And if you're trying to solicit an opinion from a family doctor to deal with a complicated vocational question in terms of whether or not, in my case, a plaintiff is disabled enough to go back to work, it's not going to have a lot of probative value. And if the central issue at the trial is in regards to past and future income loss, and the jury has to make a determination over whether or not the disability will disenable that individual from continuing to work, well, that's going to have a significant prejudicial effect. So the prejudicial effect is going to outweigh the probative value. And if that attempt to get inadmissible opinion evidence from a non-party expert who didn't comply with Rule 53.03 of the Rules of Civil Procedure is heard before a judge and they heard that, a jury rather, and they heard that, well, then that could be very detrimental, and the judge is going to have that opportunity to make that call. So those situations, if you do that error, you not only do a disservice to your client, because if the case gets thrown out or the jury gets discharged, you're in trouble, you can delay things, but you also tarnish your reputation before the judge, the court, and of course opposing counsel, and people talk, right? right? So that's a big mistake, and it just comes down to being adequately prepared early on. I like to secure my experts after the examination for discovery stage, and I like to serve those reports early, well before pre-trial.
Have you found, Andrew, that securing experts since COVID has been a bit more challenging? I had personal injury files, and finding an expert was almost impossible.
For me, no. As a solo practitioner, I'm not spending money out of my own pocket to pay for these expensive expert reports. So there's various companies out there like BridgePoint Financial who helps finance these expensive expert reports. I don't have to pay interest until 2 years after I secure it, and they have a roster of doctors within their network. Because doctors, let's face it, they want to be paid up front. They don't want to be paid after the settlement. So their doctors are from all over Canada, and I get to review their CV and get to know more about them before I get to choose. And then of course BridgePoint pays the doctor up front, and then I pay BridgePoint 2 years, within 2 years, without interest starting to accumulate. So that's really helped me out a lot. And then I've been doing this long enough, even before I started my own practice, that I've now established relationships with medical doctors and clinics who provide these kind of multidisciplinary assessments.